Yes. Good morning, Mr. Reid.
Good morning, my lady. May I start by just revisiting one or two points, having read the transcript overnight, to give some clarification. One of the issues that arose was the effect of the Cooperative Retail Society with respect to co-insureds.
Yeah.
And for your Lordship's note, that was at page 69, line 16.
Page 69, line 15.
Line 16,
Line 16,
to page
yeah.
70, line 15.
Yeah.
And that arose in the context of the submission by Conway that the ordinary rules for payment of compensation for negligence and for breach of contract had been eliminated. And my Lord then said, by the policy, and Mr. Garley said, by the existence of co-insurers. And then my Lord then said, they are not reading down anything. He is just saying there is a policy, therefore the two co-insured don't have claims against each other, they have been eliminated. Now that dialogue went on, but the thrust of it is this. By the very fact of co-insurance, any liability has been eliminated. And there was a dialogue about whether that was effectively a principle, and in CRS whether it was an analysis of the contract.
Mm-hmm.
And with respect to Mr. Garley, the position is, both in CRS and in subsequent cases, that it is, and always has been, an analysis of the contract which leads to that conclusion, and not by operation of law. And we can see that best expressed, although one finds it expressed in various places, by Lord Justice Ricks in Tycho Fire. My Lord, I think, will find it in your bundle at page 167. And in mine at G/7/18. And the top of the page is 634. I only say that because I numbered mine overnight by hand.
Oh, Mr. Reid.
Well, I just...
Read up all night, do you?
I wasn't, but I'm fearful that my numbering skills may let me down today.
I mean, I'm all for the choice between paper and electronic, but different bundle numbering, depending on which you're doing, is doubtless contrary to every procedural rule going. The same bundle numbers, however you get to the bundle, must be the first rule.
Yes.
Anyway, I'm sorry about that.
No, I wasn't saying it for that reason. It was my...
Because in the old days, your junior would have done it.
I think I was delegated. My Lord, it's if we pick it up on column 1 at paragraph 75.
Yeah.
Where he says there's another reason why I would therefore be reluctant to trespass far in not a difficult and controversial area. This is because the parties on this appeal prepared not unnaturally to take the analysis of the consequence of joint names from the authorities cited above, and in particular CRS. And although he says he's reluctant to trespass upon it, if one goes to column 2, that is what he does. It says, it appears, however, that the following doctrines have at times been put forward, and we understand that, that's what's impermissible, and that's for an insurer to sue by way of subrogation in the name of one co-assured to recoup himself from another co-assured on the basis of the latter's negligence or default. The doctrine of security of action and the doctrine of implied term in the insurance contract. Also appears that the doctrine of security action is no longer favoured, and he explains, and that's why this is important, and the doctrine of implied term in the insurance contract has now been replaced by a doctrine of the true construction of the underlying contract for the provision of joint names. That's Lord Justice Brooke and Lord Justice Hope. And that this last doctrine may operate with the assistance of an implied term to the effect that the co-assureds cannot sue one another in respect of damage in respect of which they are jointly insured. And it's, in a sense, I know I'm going to be labouring this submission, but it's because in reality it's the only one. You find it all from the contract. And every single case one goes through, one finds that as the correct analysis. And that applies whether it's for the existence of cover for a particular insured, whether it's the scope of the cover, whether it's authority, and whether it's intention. And that shouldn't come as any surprise. And I don't intend to take my lords there, but one can see it in the Scottish and Southern case, which followed Garbury. The only difference between that is that the courts have indicated that there's a presumption where the contracts provide that the parties are co-insured, that there won't be a claim against each other. And that presumption is described in a range of different ways, but all of them indicate that presumption arising from a proper construction of the contractual background is a forceful presumption, if I may put it that way.
Do we have to worry about what Lord Justice Ricks carries on to say in the following paragraphs in type of does that
Well, no.
Does that as it were underline the rationale for your solution?
Yeah. No, I did stop at before 76, but
Yeah.
the first sentence.
And the first 76 is really your proposition.
Yes, it is. Do forgive me. And then he goes on to briefly discuss there can be difficult questions, but that just isn't this case.
Okay.
But yes.
And 77, which actually is the passage that I had marked up in pre-reading, 77 goes on from that, because that's the point where he says you might get carve-outs because of the precise terms again of the underlying contract.
Yes.
So it comes back to your point from 75 that it's the underlying contract.
It is on every occasion.
I mean, I think 76 and 77 underline your point.
They do. So I'm helpful for that, grateful for that. Really, I was just correcting what I thought might have been a misapprehension. But to add the words of qualification, that there is a presumption, but it arises out of the contract. So one can take the obvious example, which we do in our skeleton argument. We pose the rhetorical example of saying, what is there an express term in the contract that the parties have the right to bring a claim against each other in such circumstances? Are we rhetorically, are we in a position where we're to override or ignore that? And the answer is that position can arise in very unusual circumstances, but it can arise. And they normally arise, and I don't want to digress, but you have a lost payee clause, so one party always gets paid no matter who brings the claim, and then they agree there'll be a claim over against another party.
Well, again, Lord Justice Ricks sort of says that, doesn't he? 77.
But the way round the problem of these days, and you can, although I don't need to take you to it, in this policy, for reasons one can't see, there's a lost payee heading in the policy, but no words underneath it. But in a typical, without wishing to give any evidence on it, in the vast majority and overwhelming number of these policies, that you find a lost payee clause, because the principal insurer always wants to get the money. And the reason why that is because, of course, if a contractor brings a claim because it's a name insured, it may go insolvent and not do the remedial works. So what happens is the normal construction of this is there's a lost payee clause, which means the money is, no matter who claims, is always paid to the principal insured. And then pursuant to the contract, it can decide for the remedial works to be paid out. But it has no claim against the contractor because of the damage, but it's in control of the money for the purpose of the remedial works. Indeed, or as often as not, another contractor is chosen to carry out the remedial works. And so the reason I simply say that is because it can give it's not anomalous to find a term in a contract saying there will be insurance in joint names, but an express term saying keeping liability alive. And it really makes the point, it's not by operation of law, it's by a proper construction of the contract. So when one comes back to that, in my lord's consideration of this, it's important to bear in mind that the first step is the interpretation of the contract. The second step, if necessary, is the implication of a term to give effect to that. The second point, having looked at the transcript overnight, is whether in all circumstances authority and intention are required. Now, our submission is that in every situation, where it be disclosed, undisclosed, or a subset of undisclosed or disclosed, you always require authority and intention. And the point that we were seeking to make yesterday is the reason why intention doesn't really arise in the disclosed principal situation is the very fact that you've disclosed that there is a principle means that intention exists because of that fact. But that doesn't mean...
Intention exists because of what fact?
Because it's disclosed. Because if you're an agent...
Because of the disclosure of the principle.
It's quite clear that you intended for them to participate. In other words, in that situation, it's very difficult, absent some form of mistake case, to think of any situation where the very fact you disclose gives the intention. Now, I indicated that there were two methods of participation in the policy. One was agency and the other was standing offer, but I've misplaced my reference, and for the note, that's in the judgment at paragraph 72, A/5/17. And the reason I take your order simply to it is because I'm making good.
Oh, this is from yesterday.
It is.
When you were the two methods of participation, the standing offer and so on, and you were referring us to the judgment, and you had mislaid the reference.
I did.
And
I was just making that good at paragraph 72.
72.
On page 71. And the reason
And so it's standing offer and what?
Agency.
Agency. And the standing offer point, help me with this, that is Mr. Justice Fraser in Haberdashers.
It is.
Is that it?
Are there only two methods?
No, is that it in terms of the proponents of the standing offer?
Yes, it is.
Approach.
And that was a case that for which permission to appeal, I understand, was sought, but it settled. I think permission may have been given, but settled between the time that permission was given and before any appellate court had the time to consider it.
But the issue there was the
it's one of the
party claiming that co-insurance was a long way down any contractual chain and potentially completely unknown and unidentified and unidentifiable.
Well, it was a contractor or subcontractor of any tier was the policy term. The contractor, as in most cases, was appointed at some stage quite far down in the works. And so one has to ask, at the date of inception of the policy, how could you have ever identified that contractor? And you come to the point where one mechanism is standing offer. Now, of course, that's all for another day, and there may be issues with that.
Yeah.
But that's not this appeal.
No, I was going to say that I was rather hoping that that's what you'd say, because then we can just focus on agency, which was fair enough, the focus of Mr. Garley's submissions yesterday anyway.
Yes.
So it's a complicated enough area without any of us wrestling with standing offers.
Correct. Carhill and Carbolic Smokeball Company, I think, was the authority cited for that.
Well, I really don't want to wrestle with that, although if you visited my room on the second floor in this building, you will find that outside, and I don't know how long it's been there, is a copy of the advertisement in Carlin and the Carbolic Smokeball Company, which I proudly keep just to remind myself, contract law lesson one.
Yes, well, perhaps I put it this way, it's a diversion not for today.
Thank you very much.
Yeah. But why I'm taking through these steps is to explain why this judge, at first instance, went through it carefully, understood what he was doing, used words carefully, using nuanced terms where they were important to come to a conclusion, which we respectfully suggest is not reasonably capable of succeeding on appeal. Now, one of the questions my lord asked me was why, if fail on ground one, the appellant fails on ground one until they fail on grounds 1 to 4. And if my lord permits me, I'm going to come back to that after ground one, because having set out the groundwork, it's then important to say how it lies. So if I then move to where I was when we finished yesterday afternoon, which was with Lord Glennie in Scottish and Southern, where I was explaining, coming on to the point, in fact, about CRS, which I said at the beginning, having revisited, that when one's construing a contract, one has to construe it against the background that there must be what he described as powerful contract indicators when there's a contract term being for joint names.
Let me just turn that off again.
Uh,
So we're
in
back
my
in
number,
SSE.
We are.
Tab 12, page.
It's 71, paragraph 403.
403.
403. So it's at 347 in your bundle, I understand.
What is important for present purposes?
Yes, if I catch up. Yes, do forgive me. The strength of the presumption. And it's making that point good. And the reason why I take you there, again, is one, in this area, one can go through a large number of authorities, all that make the same point. But I, on each occasion, try to look for a summary where the last word on summary, and this is it, inconceivable, absurd, suggests the need for powerful contraindications if such a term excluding contractual liability is not to be implied. And
does he identify, because we've come in, I'm sure we looked at this yesterday and I've just forgotten, but where does he identify the presumption?
Oh, he's gone through the cases, I think, on the previous 2 pages, but it's all to do with what he's looking at is Garberine, which discusses that. So Lord Mance does it, Lord Coulson mentions it, and so forth.
Right.
But you find throughout there these words used. And really he's summarising the 2 points. The point that I made yesterday, which is there were Lord Sumption said there were 2 questions. Lord Coulson was dealing with the first question, which was the existence of co-insureds. The second question was rights of subrogation. Now the reason, so we say things have got confused, is because Conway started with the second question and then said, well, therefore reference to Lord Coulson, paragraph 139 in Gardmarine, shouldn't have been cited. Whereas in fact, if you start with the correct question first, which is, as all these cases do, identify the nature of co-insurance, which gives rise what gives rise to co-insurance defence, which is the contract. It then becomes explicable why Lord Coulson says in the first sentence, and I don't need to take you to it, paragraph 139, that it's all about the contractual arrangements. So when this judge cited it in the judgment, he was doing precisely, so I respectfully submit, what you'd expect him to do. He's starting off with the genesis of the legal issue before seeking to apply. And so, in a sense, with respect to Lord Sumption's two questions, it's only the first one which was relevant, and that was dealt with by Lord Tours. There is no, Lord Coulson, to put it another way, question does not come in the context of a claim over. He was addressing and summarising the fundamental question that arises as to whether there's co-insurance defence at all. And that required the court to examine the basis upon which Conway was entitled to participate in the policy and any limits on that participation. Now again, my lord asked a question yesterday where he said, well, if somebody is a disclosed principal and somebody is an undisclosed principal, and authority and intention is important only for undisclosed principal, as they say it is, and therefore one doesn't look at the contract. You can have a position where simply the voyage of discovering who the principal is leads to different cover under the policy. And when Lord Justice Coulson asked, well, what's the logic behind that? The only response was, but that's the law. With respect, that's not the law. But if it were, one would try and divine some justice, legal principle, which would justify such a, we respectfully submit, perverse result. And there simply isn't one. Simply the voyage of trying to discover who is an insured is step one. Having done that, we respectfully suggest the cover you get if you pass through that gateway should be entirely the same. And the very fact of that odd result should have raised a red flag in Conway's submissions. Something was inherently wrong for that result to arrive. Now, going through the authorities, as Mr. Garley did, he spent ages explaining what wasn't in the authorities, but very little about what was in them. And that was for a very good reason. They can't actually make good that proposition. At best, there is a, if I may put it this way, he took you to, I think, a throwaway remark in National Oil Well. And I say that with greatest respect to Mr. Justice Cole, because it was the introductory words at your page 77 of the authority at my G/4/12, internal reference 593, column 2. And this is really the only reference that we can find to that proposition. There is no other.
Which paragraph?
It starts in view of the fact.
Yeah.
And it's really the first three lines. In view of the fact that National Oil Well was not specifically identified as co-insured on the face of the policy, the question arises. So it's written the other way round. At best, it's obiter, of course, because those weren't the facts of National Oil Well. Secondly, it places far too much emphasis on those words to say, as a result of that, in a situation where you are an identified principle. You do not require intention. So, and that's in a sense advocating on behalf of Conway, as far as we can see, their best possible case. It appears to have been no part of the submissions in the case, as best we can see, merely an introductory remark to come to a separate point. As for the application of authority generally, the fact that it's a question of construction, of course, was an issue considered by Mr. Justice Fraser in Haberdashers, where he took exactly the same point.
Sorry, this is...
I'm turning back now to the CRS and to say it's always a question of construction of the contract. And my point is this, in summary. If that were to be wrong, there's a line of authorities that would also be wrong.
Yeah, I understand.
And so, if I may perhaps be forgiven for 2 minutes to digress on the essence of all this insurance. Although it's being considered by this court in the context of construction, its history goes way back before that, as one can see from the authorities, as best one can see almost to 1600, where cargo was transported and there were joint names insureds, and there were shipping, and that wealth of authority is hugely established, and one always approaches it with a level of caution because it's directly applicable to this form of insurance. The only difference between the two is, in a sense, unique problems arise in relation to insurance in one of two ways. The first is that it's unusual to have insurance taken out at a time when something doesn't exist. So in almost every construction project, the insurance is taken out at a time when nothing exists. And what's unique about it is that the insured property changes with time. So to take the most obvious example is, for instance, the construction of a concrete structure. Because the insured property starts, first there's nothing, and then it starts with the materials, the aggregate, the cement. I don't labour the point, but one understands that's insured and it can be damaged. But then that disappears. It then becomes, when it's all added together, a composite material which is yet to set. That's insured property which can be damaged. That then disappears and it finally becomes the permanent works. And what's unusual is that when it becomes the permanent works, at that stage generally the insurance stops and it moves over to more general property insurance. So the reason why one has to tread with care, that's the first reason, that the nature of insured property in construction means insurance is often challenged to work out what the insured property is and how it was damaged. The second point is in relation to the number of insureds and who they are. And if one took an example, for instance, of the construction of the Channel Tunnel, it's constructed over a very long period of time, and no one knows at the beginning not only who the identity of the contractors are, but even what they will be doing, what works are required. And so therefore, and there can be many hundreds, and if sometimes more, contractors taking part in such projects at different times. So they may be doing the same works, but one gets replaced. And that's why you have a policy, in a sense, Mr. Justice Fraser introduced it in paragraph 16 of Haberdashers, which has to be flexible. And the flexibility is identifying insured property generically and in identifying insureds often by category. But none of that should advance any submission that in identifying an insured person should give rise to a different level of cover, except by reference to their construction contract. And if one looks at those examples, one can understand why it's absolutely critical to understand what works they are doing, what are the insured works in these very large projects, and how they become an insured party, and materially to what extent. And it's interesting because Mr. Garley yesterday referred to Barclays Bank as being one of the insureds. And they were going to be an insured for a specific form of cover within that policy known as DSU, or delay in startup, delay insurance. But in fact, cover was never incepted for them. The question is, how does one work that all out? And the answer is by reference, of course, to the underlying contracts. And it's true that in some of these projects, they are complex. In many instances in construction, unlike in other areas, you have different entities forming part of the same organisation. So you often have PLC, you have Finance Co, all part of the same group, and Build Co, Management Co, in the classic PFI type arrangement. And the reason one has to tread with care is because the principal insured may actually not be the person taking out the policy. PLC might take out the policy and pay for it, or Finance Co may pay for it, and Build Co might be the principal insured for the purpose of the policy. All that becomes much easier if you say we look at the terms of the contracts to work out the status of the parties. So forgive me for that digression, but in a sense it's to raise just a word of caution that there's a good reason for the policies and their terms. There is a good reason why one looks to the contracts in the field of construction, albeit that those principles apply more widely. Now, turning back to my submissions, one can see, if I turn to the judgment, if I may, A5, at page 26. So that may well be
Paragraph
120 and 124.
120.
120 to start with, which is page 80, I think, in your bundle.
Yeah.
My Lord referred to island hopping. And what I'm going to do now is take you to the points which are least favourable to our interpretation of the judgment, and explain why, when they're read in context, it's perfectly clear what this judge was doing.
I think, to be fair, island hopping is looking at bits of the evidence that was before the judge. I don't think anybody can be accused of island hopping if they're just looking at paragraphs of the judgment, because the appeal arises from the judgment. So nobody should feel abashed about doing that.
Do forgive me. In a sense, I'll put it another way around. The judge used, for the same point, different terms. And you have to read them together. And you recall that I submit that he considered authority and intention together for obvious reasons. He also considered the point of law, which was garde marine, which I say is on a proper interpretation, completely understandable. And what, as I understand, Mr. Garley says on paragraph 120, for example, he says in the third sentence, I have to address, the question I have to address of whether the intention was for the policy to provide an insurance fund recourse to which was the sole remedy making good the loss with which these proceedings are concerned. Well, and I may be doing him an injustice, but I don't intend to. What he seeks to say is, well, really that was Lord Sumption's second point about liability and not the first point about co-insurance. But even so, so taking that as its high point, it talks about the sole remedy for making good the loss. Well, of course, on a practical level, that's exactly what the insurance does. Because you can see that, because he adds on the end of this, with which these proceedings are concerned. And that's the preliminary issue for this purpose. There were both Part 7 and Part 8 proceedings. $124.
Just on 120, appreciate it's a quotation, or it comes from somewhere else, but as a matter of understanding it, really there's a comma, isn't there? There should always be a comma. The intention was for the policy to provide an insurance fund, comma, recourse to which was to be the sole remedy for making good the loss. Yes. When you first see that, you puzzle over actually what it means. But if you stick in the comma, it's quite clear. So I haven't put a comma in every time that phrase gets mentioned, because it gets mentioned too often for that. But that's how I'm reading it.
But the key is the attachment to, with these proceedings are concerned.
Yeah.
So it's not a fund that says there can never be any claim. Yeah, it's just in relation to what's the subject matter of these proceedings.
Yeah.
Which was in fact the preliminary issue.
Yeah. I understand that.
Paragraph 124, I think, on your bundle, page 81. Was the last sentence, was the RFU intending to take out insurance covering Conway in respect of the liability for such loss? The key words again are here, with the consequence that RFU's recourse should be limited to a claim under the policy. So he's looking there at cause and effect. So he's not saying that by the very fact of the existence of co-insurance, there is no claim. He's looking at the intention here with a consequence. So it's cause and effect on each occasion. So then one comes to paragraph 125. Where he deals in the second line. It's creating a fund, recourse to which would be the sole remedy for loss suffered as a consequence of breach or default by Conway. He's talking in that context, as he was before, in relation to these proceedings and the insured losses. And again towards the bottom of that page, which was to be RFU's sole redress for loss from breaches by Conway or any other contractor. So read together, it's quite clear what the judge understood he was doing. He was simply asking himself on the true construction of the contract, could RFU bring a claim? In other words, the judge understood the juridical basis for co-insurance. Now, we say that's ground one. Now, my submission was yesterday, if the RFU are right about
Just pause a moment. When you were making your submissions on ground one. You said there were two parts. The first was that Lord Coulson was wrong, that Conway's appeal is based on that proposition, and secondly, that it's based on the proposition that the judge's findings of fact meant Conway were co-insured, and you dealt with the findings of fact yesterday, because you say you have to look at more, that you have to go beyond paragraph 106.
Yes, I am going to deal with that. It just seems to me that I was going to address your lordship's question, well, why is ground one?
Okay, so all right, so you say
I'm happy to deal with it either way. I can deal with it.
No,
I
that's
can
fine.
deal with it here because it was after the point of law.
Fine.
But I can deal with it.
No,
after fact.
So that's ground one. The point ground 1-1. That's the point of law.
Part one of ground one.
Yeah, and so you say as a result.
I say as a result, obviously, if we're right about that, they don't have a point of law on ground one, and that must fail. And I'm going to come to the fact in due course. The question is, how does that more broadly apply to the other grounds?
No.
What I submitted yesterday was that the first instance judge was correct in his application and interpretation of paragraph 139.
Yeah.
Now, the question therefore arises, what is the interrelationship between grounds 1 and 4? And we can see that, if I may take you to Mr. Garley's skeleton argument at 237. And here we're in first preliminary issue.
Yeah.
And paragraphs 28 to 36,
Yeah.
he identifies what he says is the error of law. He then goes on at paragraph 37 to say, and it's quite important, he says that error of law permeates, second line paragraphs 37, permeates the entire judgment.
Yeah.
So what he says is it infects and affects the entirety of the case.
Yeah.
And then at paragraphs 38 to 43 of his judgment, grounds 2, 3 and 4 are identified as consequences flowing.
Sorry,
from,
paragraphs?
38 to 43. He explains why it permeates.
Oh, I see. Yeah.
That and he's referring to there is paragraph 139. Now, paragraph 40, he deals with the learned, what he says is the learned judge's reliance on the 19th of October building contract, which is ground 2. And it's said to flow from the judge's focus on whether the parties intended to eliminate contractual liability.
Right.
In other words, it's the same point. Grounds 3 and 4 are said to flow from the judge erringly asking himself the question whether the RFU intended to take out a policy with the consequence that the RFU's recourse should be limited to a claim under the policy. That's paragraph 43 of his skeleton argument. So the way he frames his arguments on all three of those grounds are consequential errors from the original error of misapplying Lord Coulson's paragraph 139 of Garden-Marie.
Yeah.
Now, dealing with that slightly in more detail, ground 1, the central thesis, so we say, of Conway's appeal is the judge applied the wrong test by adopting Lord Coulson's paragraph 139.
Yeah.
And therefore, if he was right about that, i.e. the judge was right about that, that ground will fail. The central thesis of ground 2 was the judge was wrong in determining the scope of Conway's cover by reference to the 19th of October 2012 JCT contract. Also, therefore, goes back to Lord Coulson when he's talking about the critical question whether the contractual scheme precluded any claim. And I've made submissions on that on ground 1. So the focus of the inquiry is on the contractual scheme between the parties and not the fact of insurance cover. And for our purposes, the JCT contract formed part of that contractual scheme, either through the letter of intent or because the contract had retrospective effect. And therefore paragraph 139 was correct. And to that extent, ground 2 is bound up with ground 1. Indeed, when one looks at his skeleton argument, and I won't take you through it, but paragraphs 51 to 58, you can see he actually repeats ground 1 through into ground 2. And
on ground 2, you could envisage, couldn't you, in different circumstances perhaps, but you could envisage if there was a general letter of intent that didn't refer to an existing contract, and if the building contract itself was entered into much later, and if on your case there wasn't the acceptance in the pleading that the contract related back, so that if it had come much later, unheralded, then there would be potentially force in the point that, well, you don't have regard to that because, potentially you don't have regard to that because it wasn't in existence at the time of the policy.
Yes, say for we would be having, I would be making submissions on retrospective effect.
But I understand that, but I'm just.
Yes, I accept that as a proposition for this purpose.
Yeah. So it just seemed to me.
My next point was that he developed.
Yes.
In his submissions, a further point on the construction of the letter of intent that wasn't there before, which is exactly, I think, my Lord's point.
Well, all my point really was that I'd like you to deal with ground 2, even if you say, which I understand, that on one view, if you're right about ground 1, then 2, 3, and 4 fall away because of how it all links back to that. I understand that submission, but I was just anxious to make sure that you dealt with 2, 3, and 4 separately. If assume that submission didn't find favour, just assume that. Then I would like you to deal with 2, 3, and 4 because we'd be helped.
I will be dealing with them all unless your bishop indicates you're not assisted by it.
Okay.
So finishing off that point, because it's true that he's raised a new point in submissions yesterday regarding the interpretation of the letter of intent and the contractual arrangements that were there at the time the policy was incepted. And he says they contain no provisions relating to insurance. Now I'm going to come back to that separately as to why that is an unworkable solution and can't be right in the construction context. But that nuance, for my purpose of making good that all the grounds fall away except for 5 because of 1, I simply make the point it wasn't in his skeleton argument. The reality is that would be an attack on the judge's interpretation of the relevant documents. In any event, it's contradicted by the evidence because it refers to a specific version of JCT contract which contains insurance option C, and the letter of intent is always going to be a matter of interpretation. And while I'm here in a sense, this all turns on the case of Twintech. And I think that's in your authority's
We had that last night.
Yeah.
Yeah, and that's authority for any one proposition, which you look at the terms of the letter of intent to decide what the position is.
Yeah.
But again, if you just stand back with this and look at the consequences for what's being put forward, you have a letter of intent that doesn't contain the insurance terms, and you have a building contract which is entered into, although albeit has retrospective effect, can't be referred to for authority and intention. What is the position in the interim? Now, on the facts of this case, what Mr. Garley says, and we don't think he can make this anywhere near good, but the proposition is the thesis. is that, well, the Hicks and Morris conversation provides the authority. You don't have to look at intention. And therefore, we have full scope of the cover throughout. That's the theory. But if I may just ask, my lord and lady, when you retire, to consider what would be the position if there wasn't such prior discussion. So there's no insurance in the letter of intent, and it only comes available through the contract without retrospective effect. And one must ask, what is the interim position there? And where I digress to talk about construction and insurance more generally, it impacts here. Because if he would be right in what he says, a contract such as the Channel Tunnel, which is 10 years in duration, has numerous contracts, let's say, signed after the almost after the work is done. It may be an odd proposition, but in many construction cases, the construction contracts are not signed until the works are actually completed. I perhaps overstate it when I say many, but in a significant number, that's certainly the case. And it would require, on every occasion, the parties to trawl back to try and work out what the authority and intention was, because the contract in relation to the intention and authority, unlike the contract itself, could not have retrospective effect. And one can just see the level of pandemonium that would exist between insurer and putative insured that would be created, because that point will be taken on every occasion. And that may be all well and good in a very small project, but in a very substantial project with numerous parties over many years, it is, we would say, commercially unworkable. The straightforward answer, of course, is on the facts of this case, it doesn't arise because, as I've said, there's a specific contract provision. We knew what was going to be entered into. There's a term which says all of the terms and conditions in a letter of intent. And in any event, we say it is a fanciful position to suggest that the insurance is not an important part of the arrangement for carrying out works pursuant to the letter of intent. Because that gives rise to questions of, liability, questions of where the payment for the damage is going to come from, and it comes to risk allocation. It is inconceivable, if I may put it that way, that parties in a position with the letter of intent, if they ask themselves the question, what's our position in relation to insurance? I know there's a policy, but it's just not part of the letter of intent. Can you just visualise what a contractor would say? It's inconceivable, of course. But equally, the letter of intent did deal with insurance, albeit with the specific part of 6.5.1.
Yeah.
Because that's all that was needed to be dealt with. So turning to Twintech wasn't a case. Well, I don't need to trouble you by looking at it. It just wasn't a case where we had a term.
As I remembered, for once correctly, it was an adjudication case.
It was.
And it's a question of which form applied and so on.
Yes.
And on the question of the relationship between the letter of intent and the subsequent contract, Mr. Justice Edward Stewart simply refers back to Trollope and Coles and says that it's a question of construction.
Correct, my lord. And that's all its authority for. There is no... we were the ones who cited it, but it was for the proposition that it was the contract, perhaps we didn't need it, had retrospective effect when the letter of intent fell away. It was for
well,
no
I
other
don't think you do
proposition.
need it because that's accepted on the face of the pleading.
Yes, so Indeed, that's why I, in a sense, say I'm not sure. That's why it never found its way into the bundle for the purpose of this appeal. So that deals with that point. Then we have, and I'm still on why the grounds, ground 1 determines all the other grounds. We then turn to ground 3. And as I said, the central thesis of that is the judge should have dealt with Conway's primary case. Conway was a named insured and accordingly was required only to show that it acted with authority. Now obviously the fundamental problem with that is that's exactly what the judge did do. He dealt with authority and found that authority was granted by Conway to the RFU and was only to obtain insurance in accordance with the JCT option C. And as I said, when one goes back to the judgment at paragraph 125 on your page 81.
Yeah.
He says about 2/3 of the way down, I am satisfied that the policy was effected on the basis that it was providing the cover contemplated by option C in the JCT contract. And what he's doing there is, it's the words, as I picked up yesterday, where it says, on the basis. That may sound insignificant, but this judgment is economical in the use of words. And when he says on the basis, it means that he's considered, as he has done before, the issues of authority and intention. And he goes on therefore, and it's on that basis he reaches the conclusion.
So, in summary, you say that if he was right to follow and apply 139 of Guard Marine, then even if Conway were a named insured or identifiable, and you only had to show authority, well, the judge looked at that and made an adverse finding.
He did. But perhaps, because it's quite important, as I keep going back to the judgment, to understand, because the judge has dealt with all these points very carefully. And I refer to on the basis, which was his conclusion at 125, but no doubt you have in your mind where that started, that train of reasoning started. And if one goes at page 74, paragraph 90, where he's dealing with the issues. He says the first is the basis upon which the RFU effected the policy on behalf of Conway. This will require an assessment of RFU's intention at the time of his entry into the policy and the extent of its authority from Conway. In other words, not surprisingly, he dealt with it compendiously, as I've explained, because contracts are important. He understood the issue. And when you come back to say on the basis at the end, one can see the train of reasoning arriving at the conclusion. Now the reason he dealt with
125, which you've just taken us to, is the concluding paragraph of a section that starts at 91, the basis on which the RFU effected the policy. So,
I mean,
as you know, I like headings. That's the heading, that's the section.
Yes, there's a clue in the heading, yes.
Yeah.
Okay, my lord, yes. I suppose what I'm trying, because so much has been made of the judge not dealing with the issues, to be direct, it's not fair, because when you look at it, he dealt with the issues, he then analysed it properly, and then he came to a conclusion using the same terminology throughout.
Well, he identified the issues and then dealt with them.
Yes.
So one is in no doubt.
Right.
Using the headings derived expressly from the words in paragraph 90.
Yeah.
Indeed.
As if he was anticipated what we would have said about liking headings. It actually, it's clear. Thank you for pointing that out. It's clearly structured.
Yes. But it goes slightly further than that. Part of the reason why he does that is because that's how the case was presented at trial. So if we go to page 68, sorry, I've got the wrong reference there. 1 second. It's 40.
If you just give the paragraph number, we'll find the page.
Yes, it's actually, this I think is in the Conway's skeleton argument, trial skeleton argument. Oh, sorry, that I know why I've done it. I can just, because it's in the supplemental bundle. And I only need to give you the reference, because it's paragraph 43 of Conway's trial skeleton argument on the opus references F/3/68. Now, this is not intended in any way to be a criticism of the way Conway presented their case. We'd say it's correct. But they presented it on the basis of a compendious issue of authority and intention. And the learned judge can hardly be criticised when the parties before him was presenting the case on that basis. He analysed the issue, explained his reasoning, and come to a conclusion. So the long and short of that, perhaps rather lengthy submission, is even ground 3 is all turns on Lord Justice Coulson's paragraph 139 cited in the judgment. And the reason why so much weight we apprehend is placed on that by Conway is because they have to find an error of law, and it's very difficult to find anything else in the judgment upon which one can hang any argument on. Then there's ground 4.
So that yes, I see. So that's why this matters, although you are going to deal with the points individually. You say if there's a point of law, it's ground 1. So if you're right about ground 1, then you say, other than 5, which is a separate point of law,
yes.
You say the appeal falls away.
Yes, that's right.
I understand that.
And I'm just making good that point.
Yeah, I understand that. So ground 4.
Yes, the central thesis of that is the judge should have considered on Conway's alternative case that Conway had the requisite authority and intention, in other words, just not authority. Now, the reasoning of ground 4 follows the reasoning of ground 3. The judge did consider the issue of authority and intention, as I've taken your lordships to, and my lady, and found against Conway. And it's only if Conway can identify a material error in the judgment, in the analysis of the learned judge, analysis of authority and intention, that has any prospect of succeeding. And what Conway says is that the judge focused on the wrong issues for ground 4. However, the judge was correct with the interpretation application of Coulson's paragraph 139. There can be no legitimate complaint, it found. So, perhaps that was rather longer than it could have been, so forgive me for that. If I now turn back to ground 1 to deal with the substantive point, assuming my submissions are wrong on that. And if Conway is correct on Guard Marine, they still have to establish as a matter of law that the judge failed to address 2 issues which Conway contends are relevant. And that is, if Conway has an identified principle, whether prior to the 17th of July 2012, it authorised the RFU to procure insurance that could cover the loss in question. Alternatively, if Conway is an undisclosed principle, whether prior to the 17th of July, it had told Conway that it intended to procure insurance capable of covering the loss in question. Therefore, what one needs to do is go back to the judgment to understand the structure of it. And I'm going to do this at some speed because I know that by now my lady and my lords have pretty detailed familiarity with this. But if I can start at page 65, paragraph 44.
And just before you do, we're going to this because you say that they have to show that the judge failed to address,
Yes.
if they're disclosed the authority point, if not disclosed the authority of the
Yes.
detention point. And we're going to this in support of your submission that the judge did do that.
He understood the issues, he analysed the evidence, and he arrived at his conclusion on those points.
Yeah.
So, paragraph 44
Yeah.
starts, in its essence, Conway's case advanced by Mr. Garley, Queen's Counsel, was that it was insured under the policy to the full extent of the wording. This result follows, and I pick it up then again. This result followed, he said, either on the footing that Conway was an identified party to the policy or that the RFU had effected the policy on its behalf with its authority intending to have the full benefit of the policy. So despite, if I may put it, sort of quite complex issues, which were, one can see, interconnected and submissions were made covering grounds, the judge fully understood what the issue was. He then went on at paragraph 45 to identify what the Rugby Football Union's position was, and one can see about halfway down for these purposes, there's reference to the letter of intent, and the authority was derived from the letter of intent and the terms of the contract, and those documents also manifesting its intention. So it's quite clear he understood the parties' respective positions. One then goes on to paragraph 65 on page 69. He then poses the question in the first sentence. Applying the agency analysis, it's necessary to consider whether and to what extent the party affecting the insurance had both authority to obtain cover for the other party and an intention to do so.
So that was paragraph
65 on page 69.
Yeah.
Paragraph 66 he cites from Colinvo, the three cumulative conditions, and towards the end of that paragraph, before me the parties accepted this was an accurate summary of the necessary preconditions, and that's quite an important phrase, albeit in the case of Conway that acceptance was limited to cases where it was an undisclosed principle. Paragraph 90 on page 74, under the heading the issues.
Well, that's the bit we've just looked at.
Yeah. And I've dealt with paragraph 125 with the composite term on the basis.
Yeah.
So on that basis, as I said, there were two parts to my submission on ground one. The second one is, judge understood the issue, understood the law, applied the facts correctly, and arrived at his conclusion, which we submit is correct. My Lord, with respect to ground two.
Just before we leave ground one, can I just ask you this? There's some suggestion in the skeletons, although it hasn't arisen already, but I just need to check it, that there was some doubt about the status of some of the judge's comments or on Mr. Garley's case findings between 91 and 125. Because Mr. Garley says there are findings. There's some suggestion about, you say that they're summarising the evidence.
Yes, what he was doing there. Difference between small C contract and big C contracts. When he's dealing with the law, he's talking about position by reference to contracts. And what Mr. Garley has done is linked this all together.
But you accept, I think, between 91 and 125, the judge, where appropriate, is making findings of fact.
Yes, I do.
Yeah.
But one has to be slightly cautious. It's more nuanced than that, because when he's talking about the contract, sometimes he's talking about the contract in terms of the legal theory, and one can't therefore extract too much from that.
Okay.
And secondly, when he's talking about contract, it's quite clear in a sense he's talking about the letter of intent. If I may put it this way, sometimes he's talking about the contractual arrangements, which include the letter of intent, the JCT conditions, and the contract, big C, that was ultimately entered into. And so it's just a matter on each occasion of identifying, because whilst we could go through it, on each occasion it's pretty clear when you look at it what this judge was referring to and why. It wasn't an error.
Okay, well, I understand that, but it's not a point that says that in some way where he says, I find such and such, that you dispute that that's a finding. You accept that.
I accept that, save that I remind my Lord that when he was making those findings, he came at 125 in the last sentence to his conclusion that wasn't the basis upon which they were dealing.
Yeah.
To put it directly, it's irrelevant.
Fine. Okay. Well, I just, there was a point that I spotted, so I just
No, my Lord, entirely correct.
wanted to make sure I'd understood it correctly. Okay, so then ground two.
Ground two. The judge was wrong to conclude the existence, extent, interpretation of the cover under the policy affected on behalf, determined and governed by the terms of the building contract entered into 9 months later, is how they put it.
Yeah.
The consequence, they say, which is quite often you don't find in any of their submissions, is they say, therefore, the cover that Conway has is solely referable or identified by the terms of the policy, and the communications prior to the 17th of July. And that's where we go straight back into, well, what was the immediately anterior communication in the sense of communications? And the one that matters, so we say, is the letter of intent. And you've seen how clause 21 excludes representations, etc., prior to that date. And that was obviously the 19th of June. It became a contract on the 16th of July when they started. That's the pleading case, paragraph 30 of their defence. So at the date the policy incepted, to put it straight, there was a contract, there was reference to option C, the JCT was subsequently executed, and no terms, as pleaded, were materially different to the letter of intent. We've identified that the judge, because I've just taken you through the paragraphs, understood the issue. That was from my Lord and Lady's note, paragraph 90, which he considered the extent of the authority, and he uses the words an assessment of RFU's intention at the time of his entry into the policy. And he says that requires a consideration of the evidence of the dealings leading up to the sending of the letter of intent. In other words, the very thing that he is said not to have done, he expressly says he did do. and a conclusion as to the contractual arrangements, which is the classic wording, between them. He considered the letter of intent represented the parties' intention to enter into the JCT contract, that those terms applied to any work done, he clearly understood the distinction between the contract documents, the contract conditions, and the contract Big C. At the time the parties, therefore, the policy was taken out, there are really 4 propositions. The form of the contract would incorporate the JCT standard building. A contract without quantities 2011, that's recorded in clause 3 of the letter of intent. All the terms and conditions of the JCT contract would apply to any work carried out pursuant to the letter of intent. That's clause 5 of the letter of intent. Insurance option would apply. If I can that's yes, if I could just take you to the policy on that as well. The information, which was the presentation of the risk, we find divided 10 at page 162.
That was the point I put to Mr. Garley yesterday. That the tender package A07.1, the information says option C.
Yes. So, in a sense, I'm making...
So you're saying that at the time of the policy that was known because it's in the policy?
Yes, precise point.
Yeah. Okay.
However, even if we were
the
wrong
4 points, you said that at the time of the policy, form of the contract was JCT, all terms and conditions, all those terms and conditions would apply to any work carried out. Option C would apply because we've got the policy. Yes. Was there a 4th?
Oh, sorry. Do forgive me.
I may have misheard. I
no, I think you were right. Yes. There was an entire agreement clause was my fault.
Fine. Yeah. Yeah.
The next point is even if the learned judge did rely on the 19th of October 2012 contract, that would be unobjectionable. Because what matters is for what purpose he would be relying upon it. And the subsequent conduct of parties is admissible to determine the extent of the Rugby Football Union's authority. And the reference for that is paragraph 3007 of Boasted and Reynolds.
Hang on a minute.
And that's in our skeleton, but it's at G15 too.
So that give me that reference again.
It's reference to the bundle is G/15/2 in mine.
If that's an electronic bundle reference shrouded in mystery.
Page 405 in everyone else's bundle.
Thank you very much. So just one number, no letters, no
Yes,
dashes.
it's the paragraph is 3-007.
So the authorities bundle page.
Yes. 360 was it?
405.
405.
3007.
Thank you very much.
455. Is it?
405.
And if you look at the last paragraph of 3-007, the standard principles of evidence apply to burden of proof.
Yeah.
And then it goes on in relation to actual authority.
And one of the cases cited for that proposition is Magellan's Spirit.
Yes.
Yeah.
The extent of the Rugby Football Union's authority is not a question of the construction of the policy. So I'm just addressing each of the points one by one that are made against us.
So you say extent of the authority is not an issue of the construction of the
Yes.
policy.
So what we say is, even if it's the contract, it can, you're entitled to take it into account, ex post facto. But authority, the RFU's authority cannot be a construction of the policy. It must be the construction of the documents passing between the respective parties. And of course, that document passed between RSA and the RFU. But even if we were wrong on that, I have made submissions already that Conway agreed to the terms of the letter of intent, and that it agreed to the letter of intent, and therefore agreed that when the contract was signed, it would be supersede the letter of intent. And we say, as a result, it's not open to Conway to argue that authority it granted to the RFU is different from that contained in the JCT contract. In effect, we say there's a contractual estoppel there. Having agreed it all, they are not in a position now to say we're not bound by the terms of that contract in effect when it contains the authority and the intention. The next point is they say that Mr. Justice Eyre was wrong to consider the implied exclusion formed part of the underlying building contract rather than the policy. So he's saying, this is, forgive me for saying the old chestnut, is it in the policy, is it in the contract? And one could wax lyrical about that academic argument, which the Supreme Court...
Not in my court.
Yes, well, by introducing it that way, it was an indication that I had no appetite to do so in any event. But it's right to say that in Guard Marine, the Supreme Court ducked the issue. Because, and you can see it when you even look Lord Sumption, when he actually uses the words in the contract or the policy. But we do in fact know, leaving all this to one side, so they refuse to express a view on that by saying it could be either. But again, using that phrase I've used twice before, standing back. In Guard Marine, they didn't have the policy before them. So they could have only been addressing contract. And that is true in a similar situation in Tycho Fire. And my Lord Coulson asked yesterday again, question, but what if the agent didn't take out the policy? What's the position there? Well, that in fact were the facts of Tycho Fire. And on that case, in that case, the parties, but also the court accepted that it should treat as done that which ought to have been done. In other words, that the policy had been taken out to decide the respective rights of the parties. But it's pretty obvious that had they not done so, if the parties themselves agreed that to be the case, there would have been a claim as between principal and agent for breach of contract in not taking out the policy. And exactly the same result would have been arrived at.
No.
Turning again, one of the points again has been taken against us, where they say Guard Marine, Cooperative and Taylor Young are all on different facts. Well, that's true. But the fundamental principle they were arguing, which was underneath it all, was the effect of co-insurance having regard to the contractual position. And in each of the cases, that point was fully argued and dealt with. In CRS, it was dealt with by Lord Bingham, paragraph 100, and by Lord Hope, paragraph 61. So the criticism that those authorities are not germane to the issue.
Sorry, paragraphs.
Oh, for Lord Bingham, it's paragraph 100. I think you've been taken to them before, so on their sideline. Lord Hope, paragraph 61.
61. Okay.
It is almost invariably the case that authorities are decided on different facts, but the underlying principle from which they then looked further, applying it, is just the same. So for all those reasons, ground 2 cannot succeed. I now move on to ground 3. Conway was identified as insured and didn't have to demonstrate separately that the RFU intended to procure cover in respect of the relevant losses. So it hinges in not finding that Conway as an unidentified principal was insured to the extent of the policy. Because Conway had authorised the RFU to procure cover in respect of it on its behalf and had told Conway that he intended to procure that cover. This is, again, by now, in a sense, because I say grounds 2 to 4 fall away because of ground 1, I'm necessarily going to have to repeat some of the things that I have been submitting. I've identified the sole basis of that earlier this morning with National Oil Well and Mr. Justice Coleman in that, without in any sense diminishing what is a very important decision. That particular line was just an introduction to the point he was actually dealing with. My Lords will recall it was the words was not specifically identified as co-insured on the face of the policy. I'm going to give you the reference for this because Mr. Justice Coleman, having done all of his analysis, I'm quite happy to take my Lord and Lady to it, he said what by now is very obvious when he said the most obvious source of authority is the agreement. And that's at G/4/16, page 81.
Oh, we've looked at that passage.
Yes. And he then went on to say there's a strong inference that the authority to insure was coextensive with those obligations. And this is really my way of submitting that National Oil Well is on all fours with this case. He found that the authority obligation was limited and did not extend to the loss in question, again on all fours with this case. But even so, he did exactly what this judge in this case did. He went on to consider, and this is 598, column 2 on page 82, and again I don't need to take you to it, where he says, given authority from any other source to bind national oil to the policy to the extent contended by National Oil.
Hang on, let me just look at
Page 82.
page 82.
Yes, it's internal numbering 598, column 2.
Yeah, and which is the passage?
Just catching up. Yes.
Because you're submitting
It's
here.
yes, it's the third paragraph, that being the obligation of DOL under the agreement was given the authority from any other source to bind National Oil policy to the extent covered for by National Oil. He goes on to consider that. So he does. My submission is.
Oh, I see. So sorry, just so I'm clear, you say he went further than
Yes, he looked
just
at the contract, but
just
he looked at everything
confining
else.
himself to the contract.
Yes.
See page 598,
Yes.
and
But then concluded that the contract was the relevant source of the authority and intention.
yeah,
And you can see that. I don't need to take my lord and lady to the other cases. It's not surprising in most of the authorities, because there's this divergence of cases at the start. Look at the whole thing of authority and intention. Well, each one of them comes down to the same point. Ultimately, it's the contract that drives it. Now, there's been some discussion about how one describes a named principle versus an unnamed principle. I'm not sure how far that takes us. But so far as we can see, you start off by saying there's a principal insured who enters into the policy. You've got the putative insured explicitly named in the policy. And for that, we say you require authority and intention. That's the analysis that's been provided in National Oil. The next category is a putative insured, which is unnamed.
Well, can we cut through
Yes.
all this putative and possibilities?
Yes.
The judge looked at both authority and intention.
Yes.
So I'm struggling to understand actually what difference any of this makes, because he looked at both anyway, and the authorities deal with authority and intention pretty much together again anyway. So the Venn diagram points at the moment don't seem to me to be particularly relevant. They're not a named party, we know that. Is it agreed that Conway are identifiable?
Yes. Capable of being identified.
Capable of being identified, sorry.
That means outside the four corners of the policy.
Capable of being identified.
So in other words, if you go on a search, it will take you to the building contract, and that building contract is for the A701 works. It's the relevant one in place, and you can see who the party is.
Yeah.
So if you accept that they're capable of being identified, what, if any, legal consequences are of that?
Well, in our case, none at all. And that's our case. It's bizarre to suggest that because you have to go on a search to find out who the party is, the amount of insurance they enjoy should be greater or lesser. Once you've identified, the real question is, where is the authority and intention? And that's always to be found in the building contract. It's the other way around, so it's the obverse. It's Conway who seek to suggest, well, the authority was given by Morrison Higgs, you don't have to look at intention. Therefore, you don't look at the building contract. Therefore, they get the full rights under the policy. We say on every occasion, you have to look.
So there's no distinction between a identified, which is disclosed, stroke identified, or identifiable.
Not for legal principle applicable to this case, no. And one can obviously see why that we would submit, why that should be so. Because then one would have to rationalise why that distinction should have a financial effect once you've identified the person who is capable of being identified but not named. And there's no reason that we can think of why that should have.
It has no impact on the analysis of authority and intention.
No. You go on each occasion and look at it, and on each occasion, one looks at the evidence, if I may put it this way, and the best evidence is the building contract, and all the authorities say that, and that's the source of the analysis. I suppose the entirety of my submissions could be summed up this way. Look at the contract. It is said that Mr. Justice Eyre didn't understand Conway's primary case. And that's where we got into our submissions. That's in a sense, an interesting statement, because what was Conway's primary case depended on at which part of the hearing one was at. I don't mean that in any... I mean it's just a statement of fact, not as any criticism, because cases often develop in oral submissions. But equally, it's not a criticism of the court, who dealt with them all. And so the statement about whether it's a primary or secondary case just simply depended upon when one took the snapshot in time. And I'm not going to, it's all, that is all, I can go through it, but it's all in our skeleton argument. And we identify the evolving nature of the case. And involving, so we would say, is probably an understated description, because it went from, there's the policy, because we are a person who's capable of being identified, we're entitled to all the benefit, to the end, that authority and or intention, depending on the circumstances, was relevant. And one can understand that the judge, when dealing with that, was very clear that anyone can put somebody's name in a document, a contract. Whether indeed they authorised it and whether that was intended is always going to be a matter of consideration. The only time it's not with a contract is when a party signed it. And the question is whether that is a different question, but not this question. So we say there's no separate or different rule applying depending on whether Conway is specifically named as an insured or falls within the definition of insured as a member of the described class. The key question here, however, we have to keep coming back to, was it's not whether Conway is insured under this policy. It is. It was always accepted it was. And we're going all through this, and the only question is, what is the scope of the cover they're entitled to? And it's only then that one has to address these issues. And all the submissions about whether one is, how one identifies whether a party is insured is simply irrelevant. What matters is, are you entitled, or must you look at the underlying information to decide what the extent of the cover is? And we have no principle, no authority that says you can't, and National Oil Well, that's precisely what happened. It's exactly what the court did. And my lords, I hark back to my example of the Channel Tunnel, where one can see that projects which go on for very long periods of time with very large numbers of contractors, of course you must look back to look at the scope of the cover. Somebody might actually just put a small nut and bolt in through to building massive structures. The scope of the cover is always dependent on that. It's entirely consistent with Colin Vaughan and the three cumulative conditions I've taken your lordships to. The key point, as ever, is there is no reason why the scope of Conway's cover should differ depending on whether Conway is named or simply described. So the legal question of whether Conway was required to demonstrate intention of the RFU makes no difference to the outcome, because that's not the issue. The judge dealt with all these issues compendiously. That takes me on, and I am going to raise it in case my lord and lady want me to deal with it, but again with no great enthusiasm to do so. It's said that counsel for RFU made a concession on this point.
You deal with this in quite some detail in your skeleton.
I do, and I don't...
in fairness, you set out the passages there, didn't you?
Yes, which is why I was hoping for the indication that I don't need to deal with it any further. It's all in there. My one line would be this. The point is based on a quotation with one line missing from it, from the transcript. If one goes and looks at the line, it sheds a great deal of light on the point that I was actually referring to. So, the reference point in this case is Mr. Justice Coleman in National Oil. And the reason for that is because he was considering directly analogous issues. In that case, there was a definition of the assured being subsidiary associated companies and or subcontractor of whatever tier. National Oil Well was a subcontractor. There was no dispute that it fell within the definition of assured. It was a simile factually in the subcontract predated the policy. And therefore, like Conway, National Oil Well could have been ascertained at the date of the policy. He identified the crucial question that it was to be determined by reference to the authority conferred on National Oil Well and the intention of Davies when procuring the policy. It must be unobjectionable, we would say, that this judge followed the same reason. Ground four. The judge erred.
Just before we leave that, does it make any difference to that submission the comments of Mr. Justice Leggett, as he then was, in the Magellan spirit?
No, that was to deal with objective and subjective intention.
Yeah.
This judge considered it, took into account the correct test, which was objective intention.
So just so unpacking that, so the objective subjective intention point is raised in Magellan spirit as a possible doubt about some of the approach, albeit the obiter part of the exercise,
Yes,
by Mr. Justice Coleman.
correct.
But you say that doesn't arise here because the judge simply looked at the objective.
Yes, he
intention.
took into account, if I may say, neutrally, the clarification. But the underlying reasoning by Mr. Justice Coleman in National Oil Well is directly applicable. So, to put it another way around, we don't rely upon the bit that in numerous authorities, issue has been taken with that. So Mr. Justice Fraser did so in haberdashers. Mr. Justice Eyre did it here. They've all accepted the test is objective, and that's all this judge was doing.
Yeah, so you don't rely on the bits of National Oil Well
No.
where Mr. Justice Coleman might have gone beyond that.
Yes, but equally, you can see where National Oil Well has been applied in the other cases by parity of reasoning, similar points.
Yeah, okay. All right, so that's ground 3.
Ground 4. The judge erred in not finding as an unidentified principle was ensured to to the extent of the policy because Conway had authorised to procure cover in respect of the relevant losses and told Conway that it intended to procure. Well, this is a simple one for us. We say that this is, by another name, an attack on the factual findings of the judge. There's a whole raft of paragraphs been cited of the judgment that we say what Conway is seeking to do is rely upon the discussions of Higgs and Morris as if they were the only relevant discussions that were taking place, and without reference to that last sentence in paragraph 125, where the judge obviously accepted they were honest, that they had certain views in mind, but Mr. Higgs, he was wrong about that.
Well, I mean, those are the submissions you made yesterday afternoon, aren't they?
Yes,
I mean,
and they are.
Those are the submissions that are in full focus for this point.
Correct. I did sort of preface my embarrassment by saying because of my submission that grounds 2 to 4, dependent on ground 1, necessarily I have to traverse some of the same ground.
Of course.
But if my lord has got the point, I'm happy to move on.
Yeah.
Now, I'm sure Mr. Wheater is going to develop this, but there's one point in his skeleton I would. There are many points in his skeleton which I would invite you to consider, but on this basis, one in particular, which is that where he says that the intention of the agent, when one's assessing the intention of the agent, must be assessed against 2 propositions. The first is, did the agent intend to act as an agent at all? This is the conceptual question. And secondly, what contract did the agent intend to effect on behalf of the principal? And those is the second question, which is important, because it's that which is objectively assessed on the parties' dealings. And for that, you look to go to the underlying contract again, and that's National Oil Haberdashers and Kavona. I'm not going to take you through the facts because we've been through those. I'm just going to say the final line, which is the judge's conclusion was the letter of intent and the contract set out the insurance that the Rugby Football Union intended to procure. And he was correct about that. Ground 5. This is the separate ground, and it deals with the express waiver of subrogation in the policy.
Mm-hmm.
And it says their core submission, it extends beyond those matters where it's agreed that Conway is insured by RSA. In other words, if they're wrong on all the other points, they've still got a waiver of subrogation which applies to them in respect of everything.
Yeah.
So that would, by necessity, as I've made the point, would include uninsured losses. It's a complete waiver of subrogation against the insurer that says, even if it's not an insured loss, I can't subrogate to another party to recover. And there is no basis upon which that can reasonably be asserted. It was Mr. Justice Coleman in National Oil World said that that proposition, as a matter of commercial logic, is to be doubted.
What's the reference to that?
Yes, I think it's at page 88 of your bundle.
Sorry, say again?
Page 88.
Page 88, thank you.
Is down to column 1 down, I think, to the end of the page. So halfway down when it says given, through to the end of the page. I pick it up right towards the end. fact, if one were considering how all this applies,
The meaning of the waiver of subrogation clause cannot therefore be stretched to accommodate a commercial purpose, which this predominant property simply does not have.
praise. He says he makes
because
a
the
number.
losses were in that case limited to the pre-delivery that were covered.
Yes, it's the same.
Were the
point.
pre-delivery losses?
Yes.
It couldn't extend to any other.
Correct. It's the same point, really, that we would say rights and interests, right, refer to the rights and interests in the contract, and that's what they're insured in respect of. And he said, no, you know, I won't go through the reasoning, but it's pretty obvious. Now, the point they make is there's no limitation on that in the policy. The answer is if you're only insured to the extent provided, then the waiver of subrogation necessarily applies to the same extent.
So if you're only insured as per option C,
Yes,
then it's the option C that the waiver applies to.
Indeed.
Those losses, not losses for which you're not insured.
yes. Or, better to put it, other losses, other than option C losses. Now, the way that the point is taken against this is firstly to say, as my lord heard in Mr. Garley's submissions, that the waiver of subrogation in national oil world was different language to that used in this case. And there was also, although it's not in his skeleton argument, a provisions to the contrary clause in national oil world, whereas there's no such provision here. So dealing with those in turn, the waiver in this case is any insured party, whereas the waiver in national oil world was any person, company, corporation whose interests are covered by this policy. There is no distinction between a person whose interests are covered by the policy and an insured party. It is, in short, a distinction without a difference.
So person whose interest,
Are covered by the policy. So that's taking out the key operative words out of national oil world and comparing them with insured party in this case. It's the same thing.
no,
The second point they make is that the waiver in this case applied to all rights of subrogation rather than just rights of subrogation. So there's a removal of the word all. And again, with respect, all adds nothing to rights of subrogation. The third point is a new point for the purpose of this appeal, although I think it was from memory raised at the primary issue, which is the reference in national oil law to provisions to the contrary. When my lord goes back to look at that, you will see in the judgment at page 602, column 1, it's just one point, which is that it was an alternative basis. It was not the sole basis for finding it. Where it says, towards the bottom of column, there is, however, yet a further obstacle to national oil world's assertion.
Right.
So his conclusion in National L does not principally depend upon the provisions to the contrary wording. That being so, this wording properly analysed is on all fours with the National L. Now, if one can go to the judgment, for the next point, paragraph 9 divided 5, paragraph 131.
That's page 83.
Some criticism made of the last few lines of this. It's the last 3 lines. But picking up from, however, that is not the position. The rights which RSA is exercising against Conway are not rights of subrogation against Conway. Instead, the right which RSA is exercising against Conway is RFU's right to compensation for the loss caused by the RFU. By Conway, RSU acquired by virtue of its subrogation against the RFU the right to bring proceedings for the loss, and so forth. And it's taken a point, the point is taken, and you'll see in their skeleton argument, about who the rights of subrogation are exercised against. And that is just the judge's analysis which he sets out. What is critical here, however, is the judge clearly understood the distinction that the waiver of subrogation only bites on losses that are insured. And he says that also within this paragraph further up. So, whilst we don't accept the criticisms, the point of principle is entirely correct. And even if the judge were wrong on his analysis on this, and that's a matter of construction of the relevant wording, it wouldn't make any difference to the result of the appeal. Because he's understood the principle, and he's applied it correctly, and in any event, you have our respondent's notice.
So you draw attention to the waiver cannot operate to protect Conway against claims arising out of matters in respect of which it is not insured.
I suppose my submission is whichever way you look at it, that's the intent and purpose of the clause.
Mm-hmm.
Now you've heard our submissions on rights and interests. And rights and interests obviously affect the waiver of subrogation as well, because one can see they're only covered by the waiver of subrogation to the extent of their rights and interests. And we say if we're right on all the other points, it can't go beyond JCT option C, what they're insured for. Now, you do have to approach this. A policy of insurance such as this is a commercial document, which is in use just not in this country, but because this form of insurance, in a sense, got its first breaths of life in this country through the Lloyd's market and has spread so that it's almost universal throughout the world. And each one of those jurisdictions, they all look to themselves to what the commercial purpose is of the policy. And one can understand why there's a waiver of rights of subrogation in respect of the insureds, but there's no coherent purpose for waiving rights against any other purpose or to any other extent. And it's, to say the least, odd that depending on Mr. Garley's construction of the letter of intent and on the JCT contract subsequently entered into, would affect the rights of subrogation, this wording. In other words, if there's no contract in there, nothing to do with insurance in there, there would be no waiver of subrogation in there. But if the JCT conditions apply, there will be a waiver of subrogation. And it's very difficult to understand the logic behind that. The words rights and interests are conjunctive, but they clearly are intended to have different meanings and effects. And an interest can, as Mr. Garley quite rightly says, be an insurable interest, with the operative word being can, because there is a basket of rights that it can apply to. But rights is something rather different. That doesn't affect insurable interest. Mr. Garley says it does, but there are, and the example was given of a Bailey. But it clearly extends well beyond that. He's also right to say it's an indication that it's a composite policy. Ultimately, though, it's a question of construction. And one can see that. My lord was taken to the general accident case where they were looking at the rights and interests of a range of different parties in a wholly different situation, but the principle applies equally. So you can't look at a case and say, in that case, because what was important was the insurable interest of the party, it always applies only to insurable interest. The question is, on a proper construction of those wording in the context of the policy, what's it apply to? And on that basis, we come straight back to what the analysis of Mr. Justice Coleman in National Oil Well, that it's to the extent as provided for in the underlying contract. And that, my lord, deals with
in National Oil Well was rights and interests, that
yes.
form of words, was that it in?
That was, my lord.
That wasn't.
That was in, yes.
That was it. Right. Okay, that's fine. I can look at that later.
Oh, do forgive me, I might be wrong on that. Can you just give me just a couple of minutes to confirm it? Oh, I know what I had in mind and I'm wrong, but I know I'm wrong. I took you to page on your bundle 88. I'm taking you to column 1.
88 column 1, yes.
Halfway down, given that if the parties had not inserted an express waiver, such a term would have been implied, and such a term would have had the effect of a waiver of subrogation only in respect of losses for the benefit of the subcontractor.
Yeah.
So that's what I had in mind.
Yes, I see. So
the wording to make sure. I mean, in reality, what he's saying is, yes, it is in there. Forgive me. It's on page 75.
Page.
Down under subrogation, underwriters agree to waive rights of subrogation against any insured, any person company whose interests are covered by this policy, against any, and so forth. Ah, so your interest, yes, it's my cross purposes. You're asking about this precise wording, rights and interests.
Yeah, I was, only
Generic
because
waivers.
I'd understood that
Yes.
each to their respective rights and interests was a common
It is.
form of words. So I wondered if there was any assistance to be derived from. I mean, I appreciate what Lord Green says in General Accident. I just wondered if there was anything more recent on rights and interests.
No, I don't. That's my fault for misunderstanding.
No, don't worry.
I don't think there is.
Okay.
But the principle in National Oil applies.
But the point you had in mind in relation to 88 is that if there hadn't been such a express provision,
Yeah.
it would be implied, but it would be implied only in respect of losses insured.
Yes,
And so you rely on that to say the same would apply here.
I do, and do forgive me for not.
No, that's fine.
My Lord and Lady, those are my submissions, unless I can assist you further.
No, thank you very much, Mr. Reid. Thank you very much. Mr. Wheaton, we should start by saying that, or I should start by saying that you're alone.
I am.
In this case, which means that the court doesn't get the opportunity of congratulating your learned junior.
Indeed.
For the fact that she's not going to be your learned junior for the next
longer
after
at all.
2 weeks' time. So perhaps you'd pass on the court's congratulations to her.
I certainly will, my lord.
Yeah, okay. Now, I'm assuming that you adopt Mr. Reid's submissions,
I do.
and I'm assuming that therefore you don't intend to go over them with a fine-tooth comb,
I do not.
and that instead you'll be like a colour commentator, just stitching in the odd
The occasional bit of
apposite
shading,
remark.
my lord, yes.
Yeah, fine.
Um,
You'll get judicial heckling if you end up repeating.
my lord, that's quite appreciated. You'll understand that some of the ground that I have to tread at least trespasses near where
I
Mr. Reid
understand
has
that.
been.
We'll be reasonably generous, but not over generous.
Understood, my lord. My lords and my lady, as you know, there are two core issues in this appeal. The first is the extent to which Conway was entitled to be insured and whether that was the same as the RFU. And the second is the waiver of subrogation proposition.
Yeah.
And all of those issues overlap to some extent, and all of those issues fall to be determined having regard not only to the terms of policy, but also to the terms of the parties' underlying agreement and any other extrinsic evidence. Now, as your lordship said, you've already heard detailed submissions from Mr. Reid on all those issues. We do adopt them, and I'm not going to repeat them. I'm going to address my submissions as follows. First, I'm going to summarise the relevance of the parties' agreement to the exercise the court was required to undertake in this case. Second, I'm going to address the effect and terms of the letter of intent, which we say represents the parties' agreement prior to the date of the policy. And my lord, as part of that submission, I'll deal with the point made yesterday in relation to Twintech. Although pausing there, it will be of no surprise to your lordship that my submissions are going to be brief and they're going to be very similar to Mr. Reid's.
Yeah.
The court has heard enough about the individual provisions of the letter of intent. Third, I'm going to address the relevance of the RFU's intention when procuring cover on behalf of Conway. And my lord, as part of that submission, I'm going to briefly expand on the point my learned friend Mr. Reid alluded to in relation to the Magellan spirit. Fourth, I'm going to deal briefly with respect to rights and interests, and I mean briefly because, again, we take the same view that in accordance with the Master of the Rolls and General Accident, this is a simple act of interpretation, and those words should be given their ordinary meaning. Fifth, I'm going to deal with the basis, briefly, of the co-insurance defence, and then I'm going to deal with the individual grounds. So, my lord, moving to the first topic, which is the relevance of the parties' agreement. As Mr. Reid says, this could almost be the start point and the finish point for the appeal, because the parties' underlying contract is relevant on this appeal in at least 4 distinct ways. First, it's relevant in relation to the authority given by Conway to the RFU to procure cover on its behalf. Now, my lord, in light of Mr. Gailey's submissions yesterday, it's understood to be common ground that the question of authority is relevant in any agency case, even on his, what I'm going to call the high watermark of his case, where he is an identified principal and that somehow has an effect on the remainder of the test of agency.
Yeah.
He also accepts, as in my submission he must on the basis of the authorities, that the most obvious source of authority is the parties' agreement. And he accepts that proposition, or he accepted that proposition on page 33, 1 to 19 of the transcript yesterday, in response to your lordship's question as to whether or not he accepted that proposition regardless of any of the comments in the authorities, and he does. And my lord, we say in light of the judge's unchallenged findings, paragraphs 109 and 125 of the judgment, that ought to be the end of the matter in relation to the question of authority. Second, the parties' agreement is strong evidence as to the scope of cover the RFU intended to procure for Conway, and the importance of intention as to the scope of cover I'll return to in relation to the Magellan Spirit. Third, it's necessary to look at the parties' agreement to assess and understand what Conway's rights and interests are under the policy, and also the parties' agreement forms part of the factual matrix against which the policy should be interpreted, and that's consistent, as I'll demonstrate with, for example, Petrophene. Fourth, when looking at the co-insurance defence itself, and I'm not going to, your lordships will be delighted to know, nor would you let me, I'm not going to go through Guard Marine, Co-op, SSE. Mr. Reid and Mr. Gailey have done that. But as you've been addressed by Mr. Reid this morning, the basis of the co-insurance defence, or the presumed implied term preventing recovery between parties who are co-insured, is an analysis of the parties' underlying contractual arrangements. And this, I think, is the last of my four, but is the starting point and end point for the issues on this appeal. Because whether you're talking about the basis of participation in the policy through agency, or you're talking about the effect of the parties' arrangements to provide the co-insurance defence, there is no aspect of the case that was before the learned judge at first instance which does not require the court to have regard to the underlying contract. And for the reasons that Mr. Reid submitted, it would be somewhat extraordinary if the court was to ignore the underlying contract. Now, my lord, I want to pause here to make one point about what we don't say. We don't say, as was said against us by lady from Mr. Gailey, that there is some general proposition of law or some general proposition of agency that the party's underlying contract is determinative as to the scope of cover or to the existence of the co-insurance defence. We equally don't say that there's any general proposition of law that co-insurance must in every case be coextensive with the party's underlying agreement. What we do say, for the reasons that the court's been addressed on at length, is that the party's underlying agreement is a highly relevant factor to be taken into account in the assessment of any of the four issues that I've outlined above. And that's entirely consistent with the approach of Mr. Justice Coleman in National Oil Well. You were taken to that yesterday, page 597, column 1, which is Authorities 81, when he said the most obvious source of authority is the party's agreement. And you've also been taken to the judgment of Mr. Justice Fraser in Haberdashers, where he said the party's contract is a powerful indicator of the correct answer, if not the answer itself, and that's paragraph 62 Authorities 271. Now, my lords, I'm not going to take you through the judgment in great detail. I'm going to stay as light touch on the judgment as I can because
What's the judgment in this case?
The judgment in this
Yeah.
case. But it will be seen that the approach in National Oil Well and the approach in Haberdashers is precisely the approach the judge adopted in this case. And if I can take you first to the judgment at core bundle, paragraph, tab 5, page 75, paragraph 91. We start in what is in my submission the absolutely conventional way of looking to the terms of the letter of intent, the policy and the contract and seeing what those documents mean, because they are likely to be the principal source of authority and intent. You've been taken through the reasoning in detail, but if I can take you briefly back to paragraph 125. The sentence that starts with, for me to find that the policy was taken out on the basis alleged by Conway and with the intention and authority it now asserts, there would need to be compelling evidence to counter the inferences from the natural reading of the letter of intent and the contract. There is no such evidence. My lord, that is, in a nutshell, the approach which, in his submissions yesterday, Mr. Gailey accepted was the correct approach. This is page 29 at lines 9 to 20. He says, the exercise that Mr. Justice Coleman undertakes in National Oil Well, which we say is the right exercise, is to say, here's the cover the contract provides for, not the policy. And then he clarifies that by saying, the underlying contract provides for. Then he says, is there anything else that shows greater authority that was conferred? Is there anything else that shows that the agent manifested greater intention? And is he prepared to look for those things in the pre-contract negotiations for the underlying contract? He's prepared to look for these things in communications after the conclusion of the underlying contract, and he's even prepared to look for those things in conduct. Well, my lord, that is the approach that my letter from Mr. Gailey says the judge should have adopted. He says that's the right approach. And without labouring paragraphs 91 to 125, that is the approach the judge adopted.
You were reading from the transcript, were you?
I was reading from the transcript.
And that's
page 28, lines 9 to 20.
Thank you.
The long and the short of it, we say, is this. On every occasion in which the extent and scope of cover afforded to a co-insured has been considered, the court has approached that task by reference to the underlying contract. And we would say there
is an underlying contract.
well, I'm going to take you to Petrofina. In fact, my lord, I'll do that right now.
Well, I was just qualifying your submission by what I'd assumed. Well, I think you said you were going to come to it. But,
my lord, I'm going to take you to Petrofina right now. So if we can go to authorities to it's page 33 is the beginning. I'll take you to the relevant section.
thank you.
My lord, before I start, can I just give you the headlines of what I'm going to say about Petrofina?
Yeah, hang on. Yes?
What I'm going to say about Petrofina is the judge spent quite a lot of time analysing the contract between the parties. And he did so in order to work out whether Magnalode and Mamoe would fall within the scope of the definition of the subcontractor under the policy. And your lordship will have seen, and I don't need to take you to it, that there was a policy taken out but then there was a specific extension to cover to include the hydrojacking works that were going to be done by Greenolsh, that were then later subcontracted to Magnalode and Mammoet.
Yeah.
The point that I want to make is this, and we're actually going to start, if I may, my lord, at the back of the authority. If I can ask your lordship and your lordship to turn to page 47.
Yeah.
Now you'll remember that the basis of the decision in Petrofina was that Mr. Justice Lloyd considered that the rationale underpinning the co-insurance defence was the principle of security of action.
Yeah.
And your lordship's seen how that's developed through the authorities, and we get to ultimately the dicta of Lord Sumption in Guard Marine, where he says, to paraphrase, it's not clear how it could possibly be security of action. The insurer is never a party to these claims.
Yeah.
So the premise upon which Mr. Justice Lloyd decides Petrofina has been discarded. But what he says at page 141, B to C, is Mr. Hamilton, who is counsel for the putative assureds, had an alternative argument. Should he be wrong in everything else? He submitted, having regard to Foster Wheeler's obligations under clause 32 of the main contract, to take out insurance in the joint names of all the parties, including subcontractors, and having in regarding particularly to the endorsement under the policy was specifically extended to include the erection operation subsequent dismantling of the hydrojack system, a contract is to be implied between the plaintiffs and the defendants, that the plaintiffs would not hold the defendants liable. And he goes on to say there is much to be said for that argument, but having already decided it on the basis of security of action, I don't need to go there. And what he's saying is there's much force in that. But I'm going to work backwards from here. The submission based on clause 32 demonstrates there was a co-insurance provision in the contract. And my lord, if I can take you to page 39.
Yeah.
At the top of the page, so if I can take you just to the bottom of the page, page 38, we've got the purchase order from Greenham's to Magnalode. Then, under the heading Scope of Work and Conditions of Order, the judge quotes two paragraphs. At the top of page 39, the general conditions of contract in line with those which Greenham Plant Hire have accepted from Foster Wheeler are understood to apply to this order. So, my lord, the insuring provision in the Foster Wheeler contract, one assumes is stepped down into this contract, forming part of the Foster Wheeler condition. And then staying on the same page, my lord, in relation to the question of interpretation, the point was taken by Petrofina that the policy applied only to the contractor and to subcontractors. And the point was taken by Petrofina that at best Magnalode was a sub-subcontractor and Mammoet would be a sub-sub-subcontractor. And this was not a policy written on its face to include subcontractors of any tier. And in construing what the meaning of subcontractor was under the policy, your lordship will see at paragraph 133C that the term subcontractor is defined in the head contract as meaning any person to whom the preparation of any design, the supply of any plant is subcontractor, irrespective whether the contract is in direct contract with subcontractor.
Very wide.
Very wide. So, my lord, this is an example of the court, even in Petrofina, using the underlying contractual framework to interpret the policy. And it's my submission that once the doctrine of security of action goes out of the window, were Petrofina to be decided today, it would be decided on the implied contract analysis, which is now favoured by the Supreme Court in Guard Marine, which is precisely what Mr. Justice Lloyd says at page 141. So, my lord, Petrofina doesn't assist you in the question of, what do you do if there's not a contract? Because there was one in this case. It's just the judge decided the case on different bases. And had Petrofina been decided today, it would be decided in accordance with conventional principles. Now, my lords and my lady, It is 2 minutes to 1.
Yeah.
That is all I wanted to say.
On your first.
Save to say that Conway's position is somewhat untenable. So the court can't have regard to the underlying contract between the parties in these situations.
Yeah.
That's all I wanted to say on submission 1. Is that a convenient moment?
Yeah, well, we've got the excitement of the letter of intent and twin
You
intent,
do.
so
With
I
bated breath.
don't think the court can take any more excitement for one morning, so we'll come back at 2.